You have 3 witnesses that you subpoenaed. The state made arrangements for them to be here. Whatever order you want to call them in this morning is fine, but those 3 are here.
That's what I was trying to address right now. I was asking about the name.
Okay, go ahead. What do you want to address?
The Kohler, how do you pronounce the name? Kohler? I'm still
I don't know,
having
you'll have to ask the witness.
I'm still having trouble finding the file for that particular witness.
Yeah, call the jury in.
So I don't know how I'm supposed to.
Mr. Brooks, you were well advised. These are your witnesses that the state made arrangements. You knew who was going to be called. I put that on the record yesterday. So of those 3, whatever order you want, but I'm not moving past those 3 to jump to others.
I didn't say anything about moving past the 3.
I know that. I just set the tone for today that we're going to keep moving.
Okay, I simply stated I'm not ready to ask that witness questions if I can't even find your paperwork.
But that's you not having your paperwork's on you, not anybody else.
So what am I supposed to ask him?
I can't answer that, sir. And you know that.
That's a rush to judgment. You can't rush me to judgment when I'm notifying the court that I cannot find the record.
Well, you did very well yesterday without your file, so
I'm saying that particular witness.
I'll make a record. Yesterday you asked a question, hold on a second. Can you have them step back out? Just so they can. Yesterday, you said you did not have a file for one of the witnesses, and you did a fine job from my perspective. So
I did what?
You did a fine job. I just want to say my assessment. You did a good job.
They also provided me with one sheet for that particular witness at that time. Okay. So I just went off of that 3 paragraphs.
How you're prepared or not is solely on you, sir. You've had all of this information. Now we're at the end of the 3rd week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How can I be prepared for? I'm not. So the witness is just supposed to get up there and just. I'm just like, yeah.
I'm not going to have this commentary. Okay, I'm done. The jury's coming out. Be prepared to call one of the 3.
So that's a rush to judgment.
That is not a rush to judgment.
It is a rush to judgment. It's clearly a rush to judgment if I'm telling you that I don't have the file.
In my opinion, you're attempting to delay. So
no, I'm not. I'm not attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks.
And Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah, and they deserve to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I still had another one that didn't have nothing to do with nothing we just talked about. There was a whole nother issue that needed to be addressed that I needed to bring on the record to your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
just like the rush to
judgment. Time for evidence to be presented or arguments to be made by the parties.
I can't even present any evidence. You won't let me even put any evidence in the record.
All of these statements made by Mr. Brooks at this time. All right.
That's unfair what you're doing.
The court will address legal matters outside the presence.
Then we need to address the legal matter that I was trying to get to before you rush everything out.
You may call your next witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant.
Mr. Brooks,
you're supposed to be able to answer simple questions.
Mr. Brooks,
if I'm saying I have to bring it to your attention.
Call your next witness, please. That's the stage of
I have to bring it to your attention, Your Honor.
Mr. Brooks,
I'm merely seeking to bring an issue to your attention.
I'm telling you to please. I'm asking you to please stop.
And I'm asking you
because we have the jury present.
I'm asking you.
We need to continue with the evidentiary phase of this trial. Call your next witness.
I'm asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will do that at the next break.
There was a legal matter that needed to be addressed beforehand, so we don't have to take up time, valuable time afterwards to address something that needs to be addressed now. That way, the court and you yourself are on notice.
I will address it at the next break. Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this. Seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony. We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
so you're going
call
against
your next
your
witness,
sworn
please.
oath. You're going against your sworn oath
Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going to take testimony right now. Call your next witness.
I merely seek to put you on notice, on the record, for something that needs to be brought to your attention and to the court's attention.
And I will address it at the
That's
next
what I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call your next witness, please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment.
There is
here,
a rush to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a public servant?
It is 9:37. Call
It is
your...
8:37.
Sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next witness,
We had
please.
a legal matter that needed to be addressed, and I'm merely trying to notify the court.
Telling you I'm denying the request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
how
call.
How can you deny something that we're supposed to do before the jury even comes out?
Call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this every day.
Everyone is in the courtroom waiting for you. Please call your next witness.
We do this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that
writing,
need to be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You can
both?
take a minute to write down what it is. I'm not asking you to...
why it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks,
Do I not have your oath of office?
under 906.11, this court has the authority, as you know.
Do I not have,
call,
is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason, that these are three of your oaths.
You are doing this,
right
and
here.
I've repeatedly told you, you can see the jury's here. You're doing this.
Listen,
we need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which kills
In my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor,
presiding over. I'm not going to address that at this moment.
Is this not your
and
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them. Here, your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
we are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to that.
aware of 3 witnesses who are here.
I
Call
object to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling, and if not that, an interlocutory declaratory appeal for this matter, and if not, these need to be stayed until this matter is before a adjudicated court of competent jurisdiction, because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of the
Mr.
charges
Brooks,
against me. I don't even understand that part
I
of it.
understand
I haven't
your
been
request.
provided a complaint. I haven't, Your Honor, there's so many issues.
Mr.
and
Brooks,
I'm not
we will
attempting,
take-
I'm not attempting to be disrespectful in any way.
We
I'm
need
not
to
attempting
continue.
to delay the proceedings
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in, it should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.